Number 108, Manor of Good. Yeah, go ahead.
Ready for court, please?
Counsel, you want a rebuttal time?
David Hagstrom, representing the appellants.
You need rebuttal time?
I would like 3 minutes of
3
rebuttal,
minutes.
please.
Go ahead, Counsel. Proceed.
The fundamental issue here is whether to value the property for tax review proceedings under its current use, forest managed land, or as vacant land, which would allow it to be valued at its highest and best use.
Are you arguing that the appraisal was deficient in some way?
The
The appraisal that the judge relied on was deficient?
I think it's sufficient.
Deficient, I said.
No,
No, okay.
not mine. I do think the other appraisal is insufficient, and I will get into that into my argument very short right now.
And you say they should be valued as a managed forest land?
Yes.
Which means you only look at comparables that are managed forest land.
They should be don't necessarily have to be managed forest land, but they should be at least forest land. And there's 3 categories, 910, 911, and 912, and they're listed in my main
Counsel,
brief.
where does it say that it can't be also assessed as vacant land? Vacant, in this case, waterfront property.
Let's go to the statute. The
Yeah,
statute
tell us.
itself, and I'm going to start out with 480A. If you read it, forest land shall mean land exclusively devoted to and suitable for forest crop production. It uses the words forest crop production. Through natural regeneration or through reforestation, and shall be stocked with a stand of forest trees sufficient for a merchantable forest crop.
So again, why can't you also assess it as vacant land? That's what the town
It's
wants to
not
do.
vacant land, it's under a management plan. You wouldn't have to have a management plan for vacant land.
Is it contrary to the statute?
Yes. But it's not that statute that it's contrary to.
Yeah.
It's contrary to 302(1), which is the taxable status date statute. You have to look at both of these. This tells you where the exemption is, the 80% exemption. The current use is dictated really by RPTL.
What's the purpose of
302.
the 80% exemption? Why do you get the 80% exemption?
Because it's on the statute. You have
What's the reason the legislature enacted that statute?
to preserve natural forests in the state of New York, and that's what they said they were going.
I mean,
Isn't this
Isn't
somewhat
it to encourage people who own land to plant and maintain trees and forests in that land?
That's what the purpose of it is.
Yes.
Yes. And
So would
that's-
that purpose be undermined if it was assessed as vacant land?
It's not vacant land.
I understand. I'm saying if it was assessed as vacant waterfront property, would it undermine the purpose of the statute?
Yes. And it also undermines, you have to go to both statutes. You have to go back to 302(1) of the RPTL, which, quote, for tax assessments, it states the taxable status of real property in cities and towns should be determined annually according to its condition and ownership as of the first day of March, and the valuation thereon determined as of that applicable valuation date. This statute has been interpreted constantly to say the property should be valued on its current use without regard to future possibilities or potentialities, and may not be assessed on the basis of some use contemplated in the future.
Aren't you looking for 2 benefits, though? You're looking for an assessment based on managed land, and I understand the purpose of that, to preserve forests and also to create, a market for the wood products. But then you're also claiming the 80% exemption. So there's 2 benefits there
No.
that you're looking for.
There's only one benefit.
Well, if we look at the statute, and the 74 version of the statute talked about it being assessed as forest land, correct? And then in 76, when they amended that statute, they didn't talk about how to engage in the assessment. they just gave an 80% exemption.
Well, it's slightly different. In the 1974 version, they had the Office of Real Property Services valuing the land similar to what you would do in an agricultural land. They postponed it twice, the effective date of the statute. It didn't change their purpose, but then it went to 80%.
Didn't they replace one thing with another? I mean, I have the same question as Judge Graffio, really. In 1974, it seems to me that, in essence, they did what you're asking for now. They said, we're going to cap the valuation of this based on its use, and then they replaced that with an 80% exemption in 76.
Let me answer that, and it goes back to the former question. There is no double dipping here. The first statute, 480A, gives an 80% exemption. Now, go to the taxable status date section.
Can you address the history, the 1974-1976 sequence? What happened back then?
May I finish this?
Okay.
Just, I've tried to
But
get
this
out.
is the crux of what we're asking, though.
I'm giving you the-
Because it appears the legislature changed the way they wanted to handle the forest lands.
That
They
doesn't-
went from looking at what the purpose was, setting the baseline for the assessment, to an exemption
That's what I'm
system.
trying to address. I'm
Yeah, but you're
addressing-
looking at a different statute.
Yes, I
We're
am,
looking at
because
this
that's
statute.
where current use comes from. Current use doesn't come from 480A. I probably should have stressed that more in my.
Okay, let me, I think we understand your point, which is that the general rule, which you get from the RP, whatever those
RPTL.
initials are, is that you value it based on current use, not on hypothetical future use. And I understand that, and I think it's a valid point. But now I'm asking you to address, why isn't this a special case? Because the legislature, having dealt with the problem of overvaluation, originally dealt with it by saying, be sure you value forest land as forest land, then changed its mind and said, instead of doing that, we're going to get an 80% discount. Why shouldn't that make this an exception to the general rule of valuation on current use?
Number one, the legislature did not do it that way.
Tell us what they did do.
They changed it from a valuation that was going to be done by Real Property Services just the same way as it comes out for agricultural land, to 80%. That's the exemption part.
But wasn't the problem that they were dealing with back in the 70s, I mean, doesn't the legislative history that you quote in your brief from the 70s show that they were concerned about overvaluation based on highest and best use?
Yes, and that's why they had Real Property Services doing it first, and then they decided to change it to an 80% exemption.
But didn't
So
they deal with the very overvaluation problem you're addressing by giving you the 80% exemption?
You ignore CPLR, RPTL 3021. That is the statute. Everybody is under current use except for vacant land. So my clients are entitled to
So you're saying that
current use.
that the intent underlying the original 74 statute hasn't changed with these amendments? The intent is still the same?
Yes, I am.
Right.
And I'm also saying that the current use standard is for every property, including this property, even though it has an exemption. It would be true if you had a veteran's exemption. You would still get current use. If you had a star exemption, you would get current use.
Well,
If
but you're defining current use narrowly, though, aren't you? I mean, you're defining current use as only meaning it is vacant land. It may be forested, but it is still vacant land. Aren't you defining current use as being some kind of a subset of vacant land?
No, this is not vacant land. Vacant land has to be inactive. This is not inactive. This is.
Where does it say that in the statute?
It doesn't use the word inactive, but it does use the following words, and I will repeat them. Merchantable forest crop. Produce a merchantable forest crop. In land that's suitable for forest crop production, that's in 481A1F, and in E, where it defines eligible tract, it says exclusive of any portion thereof not devoted to production of forest crops. Again, these definitions
Well, what
say-
about vacant land? I mean, is that defined anywhere, or is
You
it
had
defined?
Go ahead.
Is it defined separately from forested land?
It's not just that it's forested land, it's under a management plan.
Okay,
Vacant land
forested
doesn't
land
have to
or a
have
management plan.
plan that's approved by the DEC.
But doesn't vacant mean there are no buildings?
No, you can have, if you had corn crops out there, would you say that's vacant land?
Could you have a forest in vacant land, but if it's not managed, is this what you're saying, Councilor? You could have a forest in vacant land, but if it's not managed and if it's not being used for forest crop production, that could be vacant, deemed vacant land. But in your situation, your forest is being actively managed and actively harvested for crop production, and that's what allows it to have the exemption. Is that
And you've
That's
made
correct.
a 10-year
That is
commitment,
correct.
right?
And the DEC has to certify, and even now, there was an amendment in 2008 that allows the American Tree Farm system, which this is a part of, to certify that it is is eligible for 480A.
Can you
Mr. Hagstrom, it's not in the briefs, I don't think, but what's going on here? I mean, it seems to me all of a sudden there's this big change. I mean, you're getting your land value 10 times more than it used to be. Is this all of a sudden? I mean, what happened to this land that all of a sudden you're going from $140,000 to $1.4 million or something?
I don't think.
What was happening on the ground? I couldn't picture.
Number one, you don't have a comparison of forest land, managed forest land, to high residential land. Zoning, let me go through what's wrong with the
What is your
appraisal.
land zoned at? Is it zoned residential or is it agricultural?
It's zoned residential, but timber, not timber, practices, if you will, are permitted in this zone. This zone is 5-acre zoning. The zoning for the 5 parcels done by Dewan, the town's appraiser, had one was 2
Finish your
acres
thought,
and the
Councilman,
rest
and
was
you'll have
4.
rebuttal. Go ahead, finish your thought.
And just that density alone, it's the adjustments that were not made on Dewan's appraisal. He only made 4 areas for categories for adjustments. Fisher did 12, and the treatise that I've cited from the Appraisal Institute has 10. I can go into them later
Okay,
if you wish.
you'll have your rebuttal.
Thank you.
Okay, please, the Court. I'm Peter Matera. I'm here on behalf of the respondents.
Go ahead, Counsel.
And you're looking to the highest and best use of this land, right?
Correct, Your Honor.
And your appraiser used comparables that included other than managed forest lands.
Yes.
And only those comparables? Didn't look at any other forest, managed forest land?
I don't know whether he looked at other forest land or not, but those are the only comparables he used, those vacant parcels.
If
correct.
the 80% exemption didn't exist, wouldn't he have a valid point? I mean, just if you treat this like any other land, that you should treat it on the basis of the way it's actually used?
When you say he, Mr. Hagstrom?
Yes.
Your Honor, if the 80% exemption didn't exist, there would be no statute. We wouldn't be dealing with this.
Well, but wouldn't, I'm saying in that hypothetical world, wouldn't you have a very good argument that the land should be valued as forest land, not for its potential residential use?
I think the only way that would be would come to pass, Your Honor, is if in fact it were an income-producing, profitable business. Then under those circumstances, perhaps there would be that issue. Certainly for
Can't you have
agricultural...
standing forest?
I'm sorry?
Can't you just have standing forest land? That you're not
standing meaning-
harvesting the wood? You're growing these trees, it's managed forest, but you're not harvesting the wood.
No,
Wouldn't that-
I don't believe that would qualify for some special method of assessment. The legislature has special methods of assessment where they deem it appropriate, such as for agricultural land, which would involve the cornfields that we discussed earlier. But other than that, it's
So it
vacant
matters
land.
whether they're harvesting something on the land?
Well, I
Or
think
it doesn't.
harvesting is one of the elements. I think the other elements you look at is whether they're planting, fertilizing, what's being done to that land to turn it into a
Well,
farm.
aren't they making a commitment for 10 years? Isn't that part of the management plan?
I think that's...
That they're not going to develop for 10 years?
That commitment is a necessary element to qualify for that 80% exemption.
But under the definition, the law gives them 30 years from the time of the original certification to harvest the trees. Isn't that so? 30 years is a long time.
But I don't think that changes the method of assessment of the property. The fact that it may be under a plan for 30 years,
I'm talking now about the definition,
the definition of
forest land.
forest land. You can call it forest land. How does that put it into a special category for assessment purposes? A question came up before regarding vacant land, and I believe the testimony at trial by the petitioner's appraiser was that vacant land, as defined by the appraisal dictionary, I forget the actual title of it, is land without improvements. And then we went on to what are improvements, and improvements would be buildings or other.
But what about the 10-year commitment? That doesn't matter?
The 10-year commitment, again, is what you need to qualify for that 80% exemption. I don't think it brings the land into some special category that says, okay, now it can only
Yeah,
be
but it's
appraised.
not a hollow, it's meaningful, right, that they make a 10-year commitment?
It's meaningful. They don't have to, making that 10-year commitment does not mean that they have to continue that land in the forestry for 10 years. It means that if they don't, they have to pay a penalty for removing
If you had land that was under either illegal or was under contract to be preserved as forest land, subject to a very large penalty if it were changed to another use, that contract would impair the value of the property, wouldn't it?
It would affect the value of the property, yes.
So here you have, isn't the relationship here analogous to a contract with the state where they say, okay, I'll keep it this way for 10 years, and if I don't, I got to pay you a boodle of money?
I think that self-imposed restriction, whether it be with the state or with the contract, usually gives the owner some benefit of the land. It doesn't then change the value for assessment purposes.
Is that the law, that if you have a piece of land that's subject to a very burdensome easement or restrictive covenant, doesn't that change the assessment?
That may be the case.
Why isn't the burden of the tax penalty the same?
The tax penalty is a self-imposed burden for which the owner is being compensated through the reduction.
Well, no more. Well, an easement's self-imposed too.
That is correct. That is correct. The easement may be self-imposed. It depends.
But it still impairs the value. I mean, it's self-imposed. It's self-imposed, but it can't be self-removed. Once it's there, you can't get out of it.
This isn't, in fact, an easement, though, Judge. This is not an
okay,
easement.
but I'm saying it's an economic burden. If I want to sell my land for residential development, I can do it. He can't sell his without paying the tax man a whole lot of money. Why doesn't that make his property worth less than mine?
Well, again, it's not an easement, but it's a self-imposed burden for which he's already
But
been
why is
compensated.
it conceptually different? I think what the judge is asking.
Why would the owner be entitled
What's the easement or this kind of situation? Why is it conceptually different? It makes the land of less value.
Well, in a way it does. In a way it doesn't. The land can still be sold at full value. The only difference is the owner, not the land, the owner has an obligation if he pulls it out of the plan.
Well, would you buy it subject to that restriction at full value?
No, I'd buy it subject to that restriction and reduce.
You'd ask for a big discount in the purchase price, wouldn't you?
Which is exactly why the 488 comparables used by Mr. Fisher are inappropriate, because he uses the value with the 488 intact, the sale price.
Which discounts the purchase. But why isn't, setting aside the 80% exemption, why isn't it in general correct to say that if there's a huge discount because the use of the land is subject to a potential tax burden, why shouldn't that discount be taken into account by an appraiser in valuing the property?
Well, because it's still vacant land. There is still, based upon all the case law that's been cited and all that I've seen, when you have a use for the land based upon its current use and condition, that required an improvement to the land. We had warehouses, we had processing plants. Even the one where there wasn't evidently a huge building, the country club, it was a golf course, and that was appraised using the income approach.
Did this change recently? I mean, why is this all of a sudden?
I don't believe so, Judge. I don't know what brings this case up at the time it does. I don't think there was, I don't believe there was any changes in the
The town has
practice.
always assessed this in the fashion in which it's been assessing it now. It's been assessing it at $1.2 million, and 4 years ago, these people decided to challenge that?
Well, actually, Judge, I think the most recent assessment from the town in the cases before the court, it was $765,000.
Whatever it is, I mean-
And I think that's in line with the previous assessments. I
Going
can't
back
say
to
that-
1995, 2000?
Judge, I believe so. I can't say that definitively, but the record does have
What I'm wondering is,
prior years.
who inspired this? In other words, is it the taxpayer who said, I've been paying too much, too long for forest land, or was it the town that said, we're getting too little for too long from land that's got trees on it, but we can say it's vacant, and we can now tax it at highest best use because it's got an overlook on the Hudson River?
I don't believe there was any change in the method the town was doing business, except I believe the property may have been classified under a 311 classification rather than a 912, which was a portion of this lawsuit as well. I don't know anything as far as actual tax dollars that's changed with any substance that brought this to a head.
It does strike me, though, that somehow the appraisal process here somehow didn't work. I mean, the court was really in a difficult position. You've got your appraiser saying over $1.4 million, and you've got their appraiser saying, what, $165,000. I mean, that's over $1.25 million difference
Well, a
in
significant
value, and twice what your assessed value.
A significant basis for that, Judge, is the fact that the comps used by the petitioner's appraiser are nowhere near the subject property geographically.
But what he says is that
And yours are nowhere in nature like this property.
I'm sorry, Judge.
You didn't use any forest land. None of
Well,
your
that's the only difference.
comparables were forest land.
That's the only
Yeah,
difference.
but
between
isn't
the
that a
subject-
major difference?
No, Judge. I submit that.
Not what they're using this for,
I don't.
in
believe-
reality.
Going back to the word use, I don't believe that this is a use for assessment valuation purposes. As I indicated before, every time we look at a property that
So
has
it's
a use-
irrelevant that they're using it, they made this commitment that they're using it, that they claim they're going to harvest the trees.
For assessment value purposes, yes.
How did it, if I could just stay on the money for a minute, how did it, in 2002, the town assessed it at $637,500, and then in 2005, it jumps to $765,000. What changed in those couple of years?
No, I think the value of property went up,
equalization rate
and I think the
change?
equalization rate changed as well, Your Honor. I think it went from 100% to 74%.
No, if I mean, let me just try this once more. If I have a, I'm under contract to restrict my land for 10 years, that does that affect the assessment of my property? Just an ordinary contract? It says I can't
The
use it.
assessment of your property? No, that doesn't affect the assessment of your property.
So even if when an appraiser appraises my land, surely he'll take into account that my use is restricted by contract, won't he?
An appraiser may do that for giving you a value as to what you may sell it for, but it wouldn't affect the assessment.
Wait a minute, the value you could sell it for is what you're supposed to be what you're supposed to be taxing him on. Isn't you supposed to tax market value?
Under normal conditions, what a normal buyer would pay for a property,
And you wouldn't pay for this property the same amount you would pay for land that was not subject to a forest land restriction.
No, I indicated that before, Judge. I would not. I would not. And I think that's what needed to be done to use 480As as comparables. You had to put in part or all of that.
You're saying the problem with the comparables is it's property that can't be sold for much money. But this one can't either.
Well, Judge, if you were to lease out the front yard of your house and then turn to the assessor and say, well, now it's only worth half as much as it was before because I can't even walk from the street to my house, I have to go around the back way, do you think the assessor would then say, okay, we're going to reduce your assessment?
Yeah, and he'd do it, too, if you didn't paint your house. I mean, there's a lot of things that go into the value of a house, and you can't say, well, it's self-inflicted, you didn't paint it, you didn't put on new windows, you didn't do this or that. And you can't say, this house would be worth $300,000 if they took care of it right, therefore we're going to appraise it at $300 and assess it at that.
I understand that, but here we do have, there you, in that instance, you do have an improvement that does have
No, but
current use
you
and a current condition.
You were
sorry.
you were arguing that this is self-imposed. And,
Yes.
and I'm drawing the analogy that so is not painting your house self-imposed and not doing other improvements self-imposed. So you can't say this is a $300,000 house, it's only worth $150,000 because by his own volition, this homeowner's chosen not to make it as nice as it could be. Similarly here, you've got land that you say because the state of New York wants to promote forestry, and you happen to have forest in your town, and they choose to take advantage of that, that's self-imposed, and you, the town, are not bound by that. You can assess it as if it was residential property on which you could build 5-acre estates.
Because it still has its highest and best use as residential property,
Only
and can still be used
Only if
in
it's
that
vacant,
method.
and so we're into the circular argument. Right?
And I submit it is vacant land. That's what it is. That even Mr. Fisher, who testified on behalf of the petitioners.
Do you see any significance to the legislative history here?
Absolutely. Absolutely. There's significance of legislative history. The legislature, two of the significant factors were under the original 488 statute as passed in 1974. They only provided for rollback penalties of 5 years of the 5-year savings. Under the current statute, it was 10 years times 2.5. So they certainly wanted to keep property with.
Is there any significance to the replacement of the to the bringing in of the 80% exemption in 1976?
Absolutely. That's the other major factor, and that is under the original statute as passed, the exemption was going to be highest and best use, less the forest value as indicated by the State Equalization and Assessment Board each and every year. They did away with that completely, and they just said, okay, assessed value reduced by an 80% exemption. So I think that's exactly what they were intending. They were intending to say, okay, we're going to assess it as any other property, and then you're going to get an 80% exemption. Mr. Fisher had testified himself that he wouldn't consider land that's seeded by nature, trees that are seeded by nature, as an improvement to the land. And he went on to say, unless it were a single species. Well, there's no evidence to that effect that there's a single species. And in fact, looking at the record, the DEC commitments indicates that there are numerous species of trees.
But you're asking the wrong person for your legal conclusion, aren't you? I mean, I don't know. Who decides whether this is vacant land or not? I mean, is that a legal question?
Well, Your Honor, I think it's vacant land based upon the fact that there are no improvements on it.
Well, we have a cornfield. Is that vacant?
Yes, but it falls under the agricultural exemption. Even under the cases such as the golf case where they say yes, it's vacant land, but it has a golf course in it, so we're going to use the income approach method. But it was still vacant land. There were no improvements on the land.
Okay, Counsel.
Thank you, Your Honor. Thank you.
Number one, it wasn't highest and best use in 74. I have it right here, and if you look it up, it had two standards, one of which was the Office of Real Property Services, the other was $40 an acre, whichever is lesser.
The statute as enacted in 1974 had legislative findings that say the problem was use of land for timber production is becoming increasingly economically unfeasible due to assessment practices which do not take into account the present use of the property being assessed. That's essentially what you're saying, isn't it? That there's the same they were dealing with the same problem that you're complaining of now?
Yes, I think so. Legislative.
Didn't they ultimately deal with that problem by giving you the 80% tax exemption? And aren't you really asking for two solutions to one problem?
No, I go back. I don't know that I'm not getting this through, but it's current use. The exemption is over here. That's 80%. Every property, including
you're getting through that that's
property.
what you think. You haven't demonstrated it to us yet.
Can I finish this, please?
Okay,
I have very little time. Every property is valued on its current use except vacant land. If you have managed forest land that is for a timber crop production, you have a use of it the same as if you had, and let me take the cornfield that's not in an agricultural district or doesn't meet the crop requirements. You're going to take that and say it's horticultural. Why isn't managed forest land with timber crop production and going in there a use? And that goes back to 3021. On the categories that were adjusted, a second flaw in the appraisal of the petitioner. He only used 4 categories to adjust his 5 acreages.
May I, there are the appraisal, I mean, I think even the appellate division said the petitioner's appraisal or the town's appraisal was flawed, but your assessment's a lot less than the appraisal, isn't it?
Well, it's more than that. Nothing for rights conveyed, nothing for financing, nothing for conditions of sale, nothing for access, nothing for utilities, nothing for zoning.
But if you didn't do a highest and best use appraisal, did you?
No.
So have you shown by preponderance of the evidence that a highest and best use appraisal, a good one, not the one he did, which may be a bad one, but a good one, would get a lower value than the town got?
We didn't do that. But
so have you met your burden of proof?
yes, I have met my burden of proof because it's current use. Finally, if the subject property were changed from managed forest land to a use of development for high-end residential, the 480A exemption would cease and the new owner would be required to pay the rollback taxes and penalties and interest. And that, according to our estimations, ranged from $1,848,000 to $1,275,000, saying that we don't fertilize the property. Regeneration is in the statute itself, and the red light just went on.
Okay, thank you, counsel.